being here. This is today's modern age. This is a new phenomenon, new waters, new areas that we're chartering here, and these technological advances, particularly with smartphones, have made it easier to solve crimes and to take criminals off the streets. But it also makes it easier and less expensive for law enforcement to track people's movements over long periods of time. And keep in mind, as we address these issues with law enforcement, there are also issues that bleed over in how organized crime, how individuals can use these types of technologies in a very nefarious way as well. But these advances make it possible to conduct either historical or real-time prolonged surveillance previously unachievable with traditional surveillance techniques. Prolonged surveillance of geolocation reveals intimate personal details far exceeding mere location. As the D.C. Circuit noted, quote, "A person who knows all of another's travels can deduce whether he is a weekly churchgoer, a heavy drinker, a regular at the gym, an unfaithful husband, an outpatient receiving medical treatment, an associate of particular individuals or political groups, and not just one such fact about a person, but all such facts, period," or end quote. Geolocation is more than just a record of where we are or were. It is a window into who we are. Do you want your Uber trip records to have Fourth Amendment protection? What about your Fitbit data? What about your smartphone information? The Department of Justice takes an interesting position on this. The Director of National Intelligence recently acknowledged that, quote, "In the future, intelligence services might use the Internet of Things for identification, surveillance, monitoring, location tracking, and targeting for recruitment or to gain access to networks or use credentials," end quote. In plain English, he's saying that the government intends to appropriate the technology you buy and conscript the companies you entrust with your data to be the arms of the state to spy on you. It doesn't seem like too much to ask the executive branch that before prying into your life, it at least convince a neutral judge they have probable cause for doing so. Protection against unreasonable government searches is a cornerstone of our democracy. It's an expectation in our life. I do believe that each American has an expectation and a right to privacy. The Fourth Amendment provides, quote, "the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated," end quote. Think about what you keep on your smartphone, everything from banking information and personal health data, sensitive communications, family photos, and who knows what in the future. It sounds a lot like persons, houses, papers, and effects to me. In April of 2014, the committee began an investigation into law enforcement's use of cell site simulators after press reports alleged widespread use of devices, also known as stingrays, to locate people. That being using the word stingray in a generic term, there are lots of other brand names that are out there. The committee discovered multiple executive branch agencies possessing these devices, with the Department of Justice alone possessing hundreds of these devices. Even the IRS has a stingray. The IRS. What in the world are they doing with that machine? I do not trust Commissioner Koskinen and the IRS with this technology, especially after the agency targeted individuals for their political beliefs. The committee's investigation confirmed, as many suspected, that law enforcement was using these devices without first obtaining a warrant. And the Supreme Court agrees. In Jones versus the United States, the Supreme Court unanimously rejected the government's warrantless use of a GPS device. In that case, Justice Alito remarked that Congress should solve these issues legislatively, and I happen to agree with that. One of our witnesses here today worked with law enforcement and privacy advocates in his state of Virginia to update Virginia's laws post-Jones to ensure they adhere to the Fourth Amendment and gave law enforcement the legal tools necessary to catch and prosecute bad guys and women in this digital age. My home state of Utah has done the same, as has California. It's time for Congress to follow the lead. I happen to have introduced H.R. 491, the Geolocation, Privacy, and Surveillance Act, in a bipartisan way, in a bicameral way, with a good leadership there in the Senate in a bipartisan way as well. It provides law enforcement clear legal guidelines when and how to use geolocation information, how it can be collected, addressed, and used. I intend to pursue all opportunities I can to make our fellow members and the public aware of this type of technology and what it can mean in your life. We're going to hear a lot today about government rules and protocols, but as Chief Justice John Roberts wrote in a case holding that police need a warrant to search a smartphone after arrest, the founders did not fight a revolution to gain access to government rules and protocols. Just because it's easier in 2016 for law enforcement to track our location and learn intimate details about our lives, it doesn't mean those details are somehow less worthy of constitutional protection. I stand with the founders. Get a warrant. We have a lot to talk about here. In this day and age, not only look as the Oversight Committee into the past, but I think we also need to look into the future. And a lot of these tools can be used in a good way to make people's lives better. But we also have to make sure on what sort of privacy we're giving up in the name of security. We had a good hearing yesterday in Judiciary talking about with the Director of the FBI, talking about a similar type of technologies and what we're going to do or not do with encryption. But dealing with geolocation is something that we want to explore here today, and we have a good, healthy panel for that. So I'd now like to recognize our ranking member, Mr. Cummings of Maryland.